So, ladies and gentlemen, here we go again. Thank you. We're running a little bit behind, but Bill's very, very efficient operator. Bill Stark's our next speaker. He has considerable expertise. Again with Bill, I googled him up, not Google, I went to the Bar website, went to the Green website, and then went, he'll love me saying this, to the Bill Stark blog. You look at the Green documentation, then you go to Bill's, then the Bill blog, and then you'll see he's talking about this, he's talking about that. A series of interesting property developments, keeping you up to date with this case, that case, and a range of other cases. He was directly involved in the first 9AC case, which was the Besser case, Owners Corporation and those sorts of matters, and he's done his blog on the more recent Lockwood case, and he's got his blog on that. I hadn't realised until I looked at some of this material just what a military man he is, because he's involved in a range of things, lieutenant with the Royal Australian Navy Reserve, legal officer, court martials. I don't know whether he's been involved in any Skyping exercises, but here's Bill.
Thank you, Mitch. No, I had no involvement in the Skyping at all, and I deny any knowledge about it. I do know the prosecutor for that particular case, and she's very happy. 2 convictions, I think last week or the week before, sentencing shortly. I think they want to hang them. That's the usual, or keel haul them in the Navy is what we do. Anyway, we're talking about amendments to the plan, Section 9AC of the Sale of Land Act. As someone mentioned earlier, there are a couple of papers floating around. Mine will land on the Greens website in due course. But 9AC specifies if there are amendments to the plan, so we're talking about sales off the plan, if there are amendments before the registration of the plan, an amendment is required by the registrar or requested by the vendor. Now, it's interesting wording, requested by the vendor. Usually it's the local council that requests the changes, but in any event, the vendor has 14 days to notify the purchasers of these amendments to the plan. Subsection 2 says, the purchaser may rescind a prescribed contract within 14 days after being advised by the vendor of an amendment to the plan that will materially affect the lot to which the contract relates. So we're talking about what is material effect. But just as an aside, what happens when the vendor doesn't meet their obligations of providing that notice? When does the time run? Suddenly you're faced with settlement and you walk in to do the inspection that was talked about before, and, well, this isn't what I purchased. No one told me this was going to change on the plan, so I didn't receive any notice. Has the time run? Raises all sorts of interesting questions. I just want to talk about 2 cases, as Mitch said. I appeared in the first. That didn't go on the blog. That's because we lost. The second case Mitch appeared in. I think rule number 1 is if you're the developer, you're going to lose. It's quite obvious now which way the Supreme Court's bias is headed. There were two cases I want to talk about, as I said. There's a development in Bamborough Road in Caulfield. It was an average suburban block. The developer decided he could fit 4 townhouses on the block, and so he cut the block in 4 with a driveway down the middle. 2 of the blocks were on the street, 2 of the blocks were at the rear of on each side, of the left and the right side. The purchaser of one of the blocks at the front signed a contract. The contract said that the body corporate had 100 shares per unit, so there was one purchaser had 100 out of 400 shares in the body corporate. Along the way, the developer, in his wisdom, or its wisdom, it was Elmer Homes Proprietary Limited, decided he was going to help the purchaser by easing them from the burden of having to carry a quarter of the obligations that went with owning the body corporate, because really it was only the rear units that were going to be using this common property. It was a driveway that ran through the middle, and then it had all the sort of gardens and things out the back. It was all for the benefit of the rear units, so the front units didn't want to be bothered with that sort of stuff. So he amended the plan. The front unit each had 1 unit out of 202, and the rear units maintained their 100 units. So suddenly you've gone from 25% buying power to 1/202nd buying power. Is that a material effect? Well, the developer argued through learned counsel that the change to the plan was actually a benefit to the purchasers, and so as a result it wasn't a material effect on their contract of purchase, and therefore they weren't entitled to rescind. Unfortunately, Justice Pagoni disagreed. He said it doesn't have to be an adverse effect, it only has to be a material effect on the contract. PSP development, which had a great name, all these developments have great names, it was called Eco Square. I don't know if that means it's environmentally friendly or it's economical to purchase or whatever it means. Eco Square was a 7-storey development. Most of the floors had 4 or 6 units on them, and out of the 7 storeys there was a lot of bicycle parking set aside. It was in the city of Port Phillip, so it was a greenies type area, to use the vernacular. And they decided, look, most of the people that buy these apartments don't want car parks, so out of the 7,000 units or whatever there were there, we'll provide 10 car parking spaces. One of the purchasers bought 4 units and he bought 4 car parking spaces, which meant that there are only 6 available for the other 397,000 purchasers. And the idea was that he was then getting a great benefit out of having 4 units, each with a car parking space. The council decided, look, we don't really like car parking spaces at all in our developments, so remove those from the contracts, remove those from the plan. And in the end, those contracts formed part of, those car parking spaces were pushed into the body corporate or common property. And as well, they deleted 1 unit. I can't remember why that was. Mitch would know better. He appeared in the case. The question then, the developer said, well, look, they've entered into 8 separate contracts. We concede we can't now deliver the 4 car parks. They don't exist, so they can rescind those contracts. In fact, it's impossible for us to perform, so that's fine. But the other 4, they're stuck. They're going to be settling those contracts, and their notices of rescission that they've served or purported to serve are invalid. The developer again contended in that case, said that the material effect must be adverse or affect rights deleteriously, must involve a change of substance of that contracted for, and the effect of the change on a lot must be determined by an assessment of entitlements and liabilities only in relation to that particular lot. So the purchasers bought 4 lots, they're getting those exact 4 lots that they purchased, there's no material effect. They argued also that the contracts weren't conditional upon each other, and there was no basis to contend that the bundle of 8 contracts should be considered as a whole. Justice Judd, he's quite a good judge, so we can't really argue with his logic, said, no, what you have to do is look at the overall plan rather than just the one particular contract. And in the end, he decided that he agreed with Justice Pagoni that the amendment need not be detrimental. Section 9AA does not expressly require proof of detriment. So His Honour goes on to conclude at paragraph 27 that there is no occasion to impose upon a vulnerable purchaser, I mean, you know where he's going straight away, don't you? The additional burden of proving detriment if the purchaser seeking to rescind is able to establish that the amendment will materially affect the lot to which this contract relates. I am of the opinion that this is unnecessary for the plaintiff to establish that the amendment of the plan was detrimental deleterious or otherwise prejudicial. I love the way judges write. In addition to establishing that it will materially affect the lot to which the contract relates. Of course, an objectively defined deleterious effect on the rights of a purchaser under contract may more readily establish materiality. The judge accepted that Lockwood had purchased 8 lots that were part of a development scheme, the essential elements of which were changed with the amendment. He concluded there were 3 relevant changes that made this a material effect. The first was the existence of 10 car parking lots in the development itself. Secondly, the existence of lot 800. And thirdly, the common property. So the changes made to the plan had the effect of enlarging the common property, which changed the corresponding rights and obligations of the owner of each apartment lot. Whether or not the 8 contracts or each pair of contracts could be considered together when assessing the material change on the apartment had undergone such a change with the elimination of the car park lots and lot 8 as to materially affect the change. So His Honour went through a whole analysis of whether you analyse the contracts as separate contracts or you analyse it as part of the overall plan, and he decided that the attempt by the defendant developer to drive a wedge between each contract, and in particular between the apartment and car park contracts, overlooked that which must have been apparent to any reasonable bystander. That there was a symmetry to the transaction. Ordinary common experience compels the conclusion that both parties would have understood that the acquisition of a car park in short supply would enhance the value to Mr. Lockwood of each apartment. The transaction, viewed as a whole, was in substance the acquisition of 4 packages, each of which consisted of an apartment and a car park. It is entirely artificial to look only at each individual contract on a standalone basis when considering the impact of an amendment to the plan on a particular lot and contract. So, in the end, I think it becomes quite clear when you look at that case and you look at the Besser case where the good-hearted developer was trying to assist the purchaser by relieving them of the onerous obligation of paying these huge charges that the body corporate was going to incur. Both developers lost, so it seems quite clear that a material effect to a plan of subdivision will not be supported by the Supreme Court. James talked about the Section 49, the vendor purchaser summons. Both of these cases were brought on that basis after a purported rescission by the purchaser. And so you get into court quickly, you get a judgment quickly, and the developer then knows where they stand. We talked also about John Rashley Shaw earlier. Shaw and Yaranova started out refusing to settle a Docklands purchase on the size of the windows. I think now he's up to case number 11. I think so far it's 11-0, and he's now been declared a vexatious litigant. So the poor man started out buying a property from off the plan in Docklands and now finds himself unable to litigate in the state of Victoria. So it just shows you where things can lead. So that's really all I've got to say about that.
Thanks, Bill. Let's be very pithy and to the point. What it says now on the program is panel discussion. What I'd really like is anybody who's got any particular questions that they want to put, very happy that you put a couple. There have been some discussions even just during the break where speakers were asked some questions. I've got a couple of questions and you're welcome to identify some questions. So let's just sit down. So here we go. We'll sit here as a panel. I might stand up here on the basis that I keep control momentarily. And I'm happy to just have hands up, whatever. But what I'd like to do is I'd like to identify, if I can, the speaker that is under the spotlight. And I'm going to start with Bill Stark because You've just heard him, it's fresh in your mind. And I had a question to do with a subdivision that I advised upon. You heard what he said about Lockwood case. In Lockwood, 4 contracts for car park units, 4 contracts for main units, separate contracts, 8 contracts in all. Bit of an issue about that. But the developer then, only on the morning of the hearing, said you can have back the deposits on the car parks. There were no car parks. Car parks got scrubbed, they became common property. And only on the morning of the hearing. So how bad is that? Pretty bad. Silk against me. But the second thing they said was, you still get the same lot that you were going to buy for the residential lot. That's not gone, that's there. And there's more common property. That's because the car parks have vanished, the common property is now there, and of course they more or less said you get the benefit of having, as a lot owner, common property which otherwise would have been a car park that you wouldn't have had. Thank you. Bill, my question to you is, I've also seen a development which shall be nameless. I've advised on several occasions on this. The plan of subdivision proposes a number of reserves. There are a number of lots being sold off the plan. The reserves in the contract plan of subdivision say will vest in the local council, City of Wynnum. There's a giveaway. Vest in the local council. So when that plan got approved, if it did, the reserves, as identified, 1 to 6, would become council land. Council changed their mind. Council have since said, we don't want the reserves, they're yours, you take them. Councils are waking up. Reserves are problems, burdensome, have to be maintained, have to be mowed, have to be this, have to be that. So what's happened? In that one, the reserves, surprise, surprise, they've become a common property. Not far away from the car parks that became common property with Lockwood. Bill, what do you reckon? Material change?
Well, I think if we both just follow what Justice Judd and Justice Pagoni have said, then clearly the Supreme Court will say that it's a material change. You've got an extra burden on each purchaser to contribute to the maintenance of this parkland or this extra area of land that they didn't have to contribute to before. So there's clearly even a burdensome material effect, but it is certainly a change to what they were buying, because their obligations to contribute to the owners' corporation have now changed.
Anybody else got a question for Bill in particular? I'm happy. Shoot.
My question probably overlaps both the last 2 speakers. Just in light of the cases with material, we note that in most contracts, developers, solicitors put the 5% the 5% rule. How do you think the courts are going to look at material today in regards to the discrepancy between the size of, say, an apartment or the size of land?
So let's get Bill to answer that first on material under 9AC, and get James to also put his opinion in on the flight and booth rule.
Yeah, in terms of material change, I think you can't contract out of Section 9AC. So by saying that, trying to define what you think material is, the court's still going to be more than interested in analysing it itself and saying 5%, well, you put that in as a guidance of what you think. We disagree by putting in an extra piece of parkland in a 1,000 lot development. It's only a 1% change or something, but we still think it's a material change. So I think the court will just completely ignore what the developer says in terms of there's no material change unless it's a 5% difference or something like that.
James, what do you think?
I agree with that on 9AC in terms of flight and booth. The common law says that essentially you can't contract out of flight and booth in circumstances where there's a substantial departure from what's sought to be delivered at settlement and what's described in the contract. So in relation to a 5% clause, that's usually deemed to be the point at which something becomes a substantial discrepancy after that. There's a case called Buckley and Drickage, which is in the paper. It'll be emailed out to all of you today. There's a decision from Justice Teague where he expressly sets that 5% marker as the normal boundary after which there'll be a substantial detriment or a substantial difference. He did say that that applies to a normal suburban allotment, was the exact words he used. So query, given that we're talking about off-the-plan sales, there's a different rule to be applied for apartments or for other off-the-plan buildings. In my submission, it's an industry standard that 5% is really the market that we all use. So I'd say that after that point, it's very difficult to contract out of. But in an extreme case where the contract is categorical that essentially whatever the developer delivers, the purchaser must accept, then I suppose you'd have a very interesting issue.
Let's go for the full Court of Appeal. Tom, what do you reckon?
I agree.
I love it. It's a McKenzie judgment. I agree with what Dixon said. Can I just comment? The section that Bill was referring to is Section 14 of the Sale of Land Act. Any agreement under which a person purports to waive any right the person may have under this Act to avoid a contract is void. So can't give up your rights. Come back and have another bite. Was there another one for Bill on materiality? Lindsay?
My question relates to being able to allow some element of change in the lot entitlement liability in the plan of subdivision and how far that actually goes. Some contracts I've seen remove the objection to a change in the lot entitlement liability and whether that would be effectively, I think the answer to the question has actually been answered by saying you're allowed to contract out of it. But
Yes.
can you actually impose a removal of the objection to the change?
Well, recently I looked at a contract for a development in Chirnside Park where the contract tried to get around changes by the plan to the plan of subdivision by the local council, and it went the contract revisions, you run to the usual 300 pages, but the developer tried to say if the council imposes changes on the plans, they're beyond our control and you'll accept those changes that the council imposes. I don't think it gets over the 9AC issue of being a material change that the purchaser can then rescind for. But it's a nice try by developers to bully their way through a difficult scenario that they're now faced with.
Can I just comment that it's nearly always the case that the contract says we will notify you for any material and detrimental change. We're not relying on the contract. Don't worry that they come back and say it isn't detrimental, as Bill found with the Besser case. You're on a statutory provision. If it's material, even if they want to say it's beneficial, material is enough for statutory purposes, but they will come back when you write your letter and say it's not detrimental. Don't care. Let's move on. James talked a bit about Harafam. That's the extension one. Contract under 9AE, it's 18 months for completion or such other date as the contract may specify. Okay? Bongiorno J said it's not specified because the vendor purported to have the right to extend when and if needed. And there were a number of cases involving that. That went on appeal. Court of Appeal said Bongi was right, and that specified means specified. We need a date. Harafam, bit interesting. But think of Harafam like this. Harafam said, let's just pick a time. The date specified is 2 years, together with the right of the vendor to extend for a further 6 months if circumstances require. And the way they argued it, first in a single judge and then on appeal, Marilyn Warren dealt with 2 of these in a row. Practice Court Day 1, Practice Court Day 2, gave a decision on them and said, not good enough, kicked it upstairs, Court of Appeal. I went across to the County Court and got Graham Anderson to say the same thing, not good enough, and Court of Appeal said 2 years plus 6 months, max, doesn't get you out of it. But the contracts are still out there and the developers are still signing them up with the right to extend. So don't think, they'll probably stop now because Harafam has nailed a lot of that. But you'll find the contracts signed 6 months ago, 2 years ago, 3 years ago that are coming through, still have it in them. So it's still open, keep an eye out for it because that doesn't have the cut-off of you can only do it within certain specific periods. So you end up saying, my question for James is, if it says 2 years plus a further 6 months if the vendor needs it because of floods, fire, drought, famine, whatever. Do you have to wait until the 2 years is gone? Does the 18-month default period under 9AE kick in? If it is 18 months, because there's no alternate period specified, because the courts have said it's not specified pursuant to 9AE, do you still have to sit there wondering whether you get your deposit back or whether they'll get it through within 18 months? Or can you just say you've failed to specify and there's no other period? James, what do you think?
I suppose you could say this, that if there's an ineffective attempt to set an alternative date for the registration of the plan, or an alternative deadline, if you like, that's longer than the 18-month period, and that's struck out by a court, then it'll revert to the normal 18-month period that's prescribed in the legislation. The way the legislation's drafted is not to render it an illegality or a breach of the Act if there's some kind of ineffective attempt to extend that date. What the legislation says is that it's 18 months or such other date as is specified, or something along those lines. And so therefore, if you fail to specify another date, then it reverts to that standard 18-month clause. Implicit in what you said, though, is another interesting point which just occurred to me, which is that you see often these severance provisions in contract of sale. So what if you drafted something like this? It's 2 years as a fixed date, and then a separate clause saying that first clause can be extended out according to all the usual things. But if that's ineffective and it's struck out, leaving you with the original extended date, something like that maybe would be legal, but really I think the cases are now showing that you've got to specify an actual fixed date, and that's now been confirmed as clearly as you could possibly have it confirmed by the Court of Appeal.
So, some Harafam type questions, extension type questions for James as to James's thing, or perhaps Flight and Booth, we've touched on that a little bit. Anything particular anyone wants to ask? Yeah, shoot. Can I I'll jump in there and invite the panel members to make further comment, partly because I'm commanding the audio. The question is, if the contract says 60 months as the specified date, is there some complaint that that's too long for a purchaser to wait? Is it unfair? This is spy and counter-spy. Developers do that, courts knock it out. Developers change that, courts knock it out. Developers are now changing, and I agree with what the questioner's asked. He said developers are now acting on the basis that they will throw it to the longest date. If they get it through earlier, that's fine, but they're not going to take the risk, and they're not going to be mucked around by specifying or not specifying. And they want to lock you in. Why? Because they've got commitments with the bank, they've got the funding, and they've got to have contracts that are going to stand up. Otherwise, their funds are gone. We all know how that works. Okay, so they are now putting in 4 years, 5 years and longer to protect their backs, to make sure it's a binding contract. The 9AE provision is if a plan of subdivision is not registered within 18 months, it used to be 12 months, then it was changed to 18 months, and now it says not registered within 18 months after the date of the prescribed contract. They sign these contracts up over a 12-month period, so some of them have to be a year earlier or later than the last one signed, the first one signed, the last one signed. Or if the contract specifies another date before the end of that specified period. There is no limit in the Act on another date. So it really invites you to specify any date you want. I think the question for the panel is there some unfairness or some opportunity to say 5 years, 6 years, 48 months is too long? What do you reckon, Bill?
Well, the High Court says if you sign a contract, you're bound by its terms. And I think that if the contract specifies 5 years or 6 years, you've been well aware that that will be how long you may have to wait before the settlement arrives, and the developer just invests your 10% in that 6-year period, and you just hope they don't go broke. Of course,
James?
Trust money.
James, unconscionable, unfair, any other opportunities?
With statutory unconscionability, there's now a new sort of moral turpitude style test that you might be able to use in a very, very extreme case. The other potential argument could be the doctrine enunciated by the High Court in Placer Developments, which says that if a contract, in essence, allows one party to, at its discretion, not perform the bargain because it's so open-ended and one-sided, then it's not really a contract at all, it's just illusory. So if it's 100 years, then you could say that, and it's a discretionary sort of thing where the vendor can just drag its heels and not do anything, you might say that there's just no real contract because it doesn't have to do anything at all.
Tom, what do you think?
I agree.
No, not good enough. All right.
I certainly reckon 5-6 years is just way too long. But if you've signed up to it as a purchaser, well, I reckon you're going to have trouble getting out of it.
Let me anticipate now. We move to Tom as the focus, spotlight on him. My question, and it's one that floated past the bench, the desk before, and Tom's given me the question he wants me to ask him, but I'm not going to ask it. The contract says you've got to settle when the architect certifies it's all basically done, save for some outstanding items and some minor defects, and a C of O, occupancy permit, is there, and there's no right to not settle, and we will deal with the defects, give us a defects list within 6 months. Tom, does that work? If you think there are a sufficient list of defects to be enough to say there's 50 grand's worth of other stuff that has to be done, does that contract mean that you have to settle and keep your fingers crossed that this builder, who's stuffed up with all these defects and things not in, will do it over the next 6 months? Can you hold some money back? If they serve you with a notice for rescission, should you serve any sort of notice to say, you've failed, you're in breach, we want our money back, because they will not want to lose you because it takes too long to sell again? What do you do, Tom?
Yeah, it's very hard. I think that the safest option is to settle and issue a VCAT immediately for in the domestic list for that stuff.
You have to give any notices under the contract, because the contract says no one shall exercise any legal rights without giving notice. Are there notice requirements or not?
Probably, I would issue a notice saying of our intention, the purchaser's intention to issue this claim. The problem with that, though, is that if the contract sets up a period of time for the builder to rectify defects, say 6 months, then you might risk being challenged in your action on the basis that you're precipitously bringing the action in circumstances where you've got to give the builder some time to rectify.
If your building consultant's report identifies the cost of rectifying the defects as more than 5% of the contract price, let's say it becomes 75 grand,
well,
flight and booth, sufficient problem?
I reckon, well, see, it's like the two examples I gave, Mr. Shaw's example of a window where he said it didn't comply properly, and the other hand where a person's effectively lost a bedroom or something like that at the other sort of extreme. What you're proposing to me is somewhere in the middle, which is where it starts to get quite hard. I mean, another example I had was someone who came to me and said, look, our bathroom has got a service duct in it and it's now half the size it was, and it pretty much doesn't work. And when you go and talk to the builder, they say, oh yeah, we forgot about the service ducts. It's got to take the water and gas and stuff up and down in the building, and it had to go through your apartment. Luckily, we managed to negotiate a price for that, diminution of value.
So let's let him off the hook for the time being. Any other questions for Tom? Shoot.
Interesting one. With a lot of the apartments, the common areas are not usually completed. I can purchase and get access to the apartment, but a lot of the other facilities are not completed. Retail areas, gyms, pools, etc. Building surveyors are generally in the pocket of the developers, and what's your view how the courts would look at a situation where a purchaser tried to rescind on the basis, look, my quality of living there is not good, or if it's an investor, I can't rent it out because of all this work continuing, common areas are not
I'm
complete.
a co-owner, I buy my lot's been put in good order, but I'm a co-owner of common property which hasn't been put in good order. Tom, what do you think?
Well, it's the same issue. I mean, are you acting precipitously? Because the developer could quite reasonably come back to you and say, look, we acknowledge that there's an issue with the common areas, but don't worry, the building's getting to that, and it will be completed, within a period of time. And the hard thing, once obviously settlement goes through and the plan of subdivision is registered, is in fact it has to be the body corporate that takes action against the developer, and it can't be the owner. Same thing with things like, say, windows that leak and stuff like that. It's not the owner that has a go at the developer or the vendor, but it has to be the body corporate.
There was another question for Tom somewhere. Shoot.
Versions of plans of subdivision that are in contracts. Inevitably, you see version A in the contract.
Yep.
Come towards settlement, you get served with version G.
Yes.
What's the developer's obligations in providing all purchases of the different versions of the plan of subdivision through?
Well, it
I'll
depends.
throw that one to Bill because that's a 9AC change in the plan of subdivision, and that's what came out.
Yep. It says under 9AC1, it actually says if a prescribed contract has been entered into and before the registration of the plan, an amendment to the plan is required by the registrar or requested by the vendor shall, so it's obligatory, within 14 days after the receipt of the requirement or the making of the request, advise the purchaser. So they are obliged to do it, but inevitably they don't. Inevitably they don't. Well, they're in breach of Section 9AC, and if it's a material change, then obviously that brings in the right to rescind. But if A to B was a minor change, B to C was a minor change, but you get A to G is a material change, and they haven't notified you along the way, they are taking a bigger risk. Whereas if they notify you, we've changed one minor thing, that's A to B, and then B to C, one minor thing. If they notify you along the way and they're all minor changes, you're not going to get to a material effect. So
Tom, were you
it's in
going
the
to express
developer's
your view?
interest to notify.
Yeah, look, if G looks nothing like A, that's pretty material.
Yep.
But if it's pretty close, it probably falls within the tolerances that the contract allows when you sign up to it.
Can I just make this comment? I have advised developers where they've needed to whack up 2 more stories on top. The penthouses were no longer penthouses, and another batch of basement car parks. I thought it was material. We made sure we told everybody early, and because settlements were 2 years away, the response rate was only from those who had solicitors. Never a conveyancer made an inquiry, and the only inquiry the solicitors made when they asked, what's this really mean, was, is the area of my unit still the same? And the answer was always yes. So my advice, for what it's worth, is developers, advise and notify early and fully, because if there's a bit of a hint that you mightn't have said everything, you might be in strife. The notifications that come through 3 months, 3 weeks before settlement, when they can't get their funds, they can't settle, and they realise it's not worth what they're going to pay, they're looking for ways out. Yeah. So if you're changing it, don't notify them about G. Get B, C, D, E in and notified. Let's keep your fingers crossed that G isn't material. We do say that we'll stop at 9. It's 2 minutes past. Hit the road. I've indicated to somebody who wanted to ask a question, and there are a couple of other questions out there. We won't answer them as a panel. Everybody's free to go. But I'm sure if you're quick, you can grab somebody before they leave and ask a question. Thanks for your time, and would you thank the speakers in the usual way?